Mr. Combs feels A, he's innocent, which is why he's not going to plead guilty. B, he's going to be truthful about this case because he wants to portray that to the people who have loved him his whole life.
At trial, Combs will ditch the jail garb and wear ordinary clothes. As his lawyers argue, the evidence shows consenting adults being intimate in their own way.
She did, and when the judge did, Diddy, who was sitting at the defense table with his attorneys, did not show any signs of emotion. He took a sip of water before he was led out of the courtroom by the U.S. Marshals. Now, his lawyers have vowed to fight this. They are going to be back in court on Wednesday before the judge who will oversee this trial and try to get Diddy to be released.
Back up a little bit, please.
How can you support your father? How do you support him moving forward?
Running a criminal enterprise. They say that he forced his employees to both work long hours and participate in a sex trafficking scheme that took place over 2 decades, that he coerced women into sex, that he held these sex parties known as freak-offs and brought in prostitutes to participate in those parties. So he is facing a litany of charges in this case and ultimately could spend his life in prison if found guilty.
Diddy had every room taped and bugged. Diddy had, bruh, can you imagine? He had every room taped and bugged, and they found little bugs and little tape recorders.
He believes he's innocent, and what's more, he believes that he needs to stand up, not just for himself, for his family, and for everybody who's been targeted by the federal government.
Major developments tonight involving the case against Sean Diddy Combs, what he decided in court today, and what this now means, the move coming just 4 days before his trial is set to begin.
Rumors refuse to die that Sean Diddy Combs is orchestrating yet another high-stakes courtroom pivot. Night Owl insiders swearing his attorneys filed a stealth motion moments before clocks struck midnight, pleading that the current Manhattan jury pool is hopelessly drenched in algorithm-driven gossip, clickbait commentary, and endless reaction clips, thereby crushing any hope of a clean slate.
Kids have like an hour left. Because this thing turns into something that when y'all get older, y'all don't want to come to.
The hip-hop monarch, already navigating an ever-thickening maze of civil complaints and looming federal counts tied to alleged SA and ST conspiracies, argues that even a flicker of pre-baked opinion could torch his future, and each procedural chess move now echoes through boardrooms, playlists, luxury vodka campaigns, and late-night talk show monologues. Long before federal marshals stretched fresh caution tape across Southern District hallways, Combs presented himself as a master conductor of brand symphonies, steering bad boy triumphs in the late 1990s. Spinning profits from fashion, labels, premium spirits, and televised talent searches, crafting a persona of bulletproof control. That armor began to dent in autumn 2023 when a volley of lawsuits landed in rapid succession, each layering new allegations onto an expanding narrative of power misused behind velvet ropes.
You're gonna hear about my party, they're gonna be shutting them down, they're gonna probably be arresting me, doing all types of crazy things just because we wanna have a good time.
By early summer the following year, prosecutors had convened a grand jury, investigators stormed 2 residences, and cable panels dissected nightclub snapshots dug up by fan forums looking for hidden context. Sponsors froze campaigns, streaming platforms weighed catalog suspensions, and longtime collaborators blitz-cleared their socials, hoping to dodge reputational fallout. Combs' first crack at reshaping the jury arrived the second week of February 2025, a mere 7 days after Judge Eleanor Vasquez penciled voir dire into an early April calendar. Defense counsel claimed prospective jurors, steeped in hourly hashtags and sensational thumbnails, would arrive tainted, while prosecutors countered no star defendant could demand a sterile bell jar, only rigorous questioning to filter blatant bias.
Well, Bill and Sade, accepting a plea agreement would mean that Sean Combs would have to admit to trafficking and force. And today he made it very clear that was not going to happen. Diddy maintained all along these encounters involved consenting adults and plans to take his chances that a jury agrees.
The judge denied that plea, yet dangled a caveat. If truly new conditions materialized, she would entertain another request, cue an explosive torrent of sealed discovery material 2 weekends ago, uploaded to an overseas file share then amplified. By countless TikTok stitches and YouTube commentary marathons, the clip, still unverified, allegedly captured ex-employees describing hush cash payouts and gag order threats, and analytics firm Q-Metric charted a sudden tenfold leap in Diddy. Trial searches across New York within 2 days.
Sean Combs is such a high-profile defendant, and it's always difficult or more difficult to find a jury in those cases. Racketeering comes with the highest sentence.
Defense lawyers seized on those numbers, labeling the phenomenon an invisible concert of whispers piped straight into every potential juror's phone. Prosecutors responded with an efficient 8-page rebuttal, reminding the bench that robust voir dire was designed for precisely this reality where total ignorance vanished with dial-up modems. They listed prior cases spanning disgraced athletes to feud-plagued actors, where saturation did not preclude impartiality once jurors swore under oath. They also noted that Combs' camp tried similar delay tactics after paparazzi footage aired. Last spring, a Gambit Judge Vasquez likewise swatted aside.
The trial hearing will start in a matter of hours in the federal sex crimes case against rapper and hip-hop mogul Sean Diddy Combs. Combs is facing at least 3 federal charges, including sex trafficking, and faces up to life in prison.
Yet, in the real world beyond the filings, the mogul's revenue network creaks. Liquor insiders whisper a nearly $60 million distribution buyout froze overnight. Licensing teams stalled back catalog negotiations, fearing royalties could vaporize in civil judgments, and marketing executives inserted pandemic-style escape clauses pegged to each courtroom milestone. Every docket ping now reverberates through spreadsheets, contract pipelines, and streaming playlist rotations. Deep inside the defense playbook, consultants quietly commissioned a demography survey blanketing Manhattan, Brooklyn, Queens, and suburban Nassau County, asking residents whether they tracked lawsuit chatter. Footnotes in the motion claim over. 78% recognized at least one civil plaintiff by name, and well beyond half consumed commentary videos about the leaked testimony. Prosecutors challenged the sample as self-selecting and hyper online, noting many older print news devotees never touched those clips.
He knows the deck is stacked against him. They've got a ton of evidence. Take the plea deal, dude. Just take it.
Well, my guess is that, because we don't know the deal of the plea deal. At least I don't think we do.
True.
Okay.
They stress that familiarity does not equal prejudice, citing white-collar juries where panelists admitted headline awareness yet judged solely on presented evidence. Judge Vasquez, wary of optics, slated a hearing for next Tuesday, hinting she may host a mini-trial on media psychology. Dueling academics, parsing algorithmic echo chambers, click-through, loops and cognitive priming. One defense expert, a former engineers turned Ivy League professor, argues modern feeds deliver tailored reinforcement so potent that prospective jurors cannot simply look away, while the government's cognitive specialist counters that impressions fade once jurors absorb live testimony, pointing to longitudinal studies where prejudgment dissolved within 48 hours of sequester. Should the judge greenlight relocation, she might import jurors from Hartford, Pittsburgh, or perhaps Charlottesville, stretching logistics by months. Should she decline, defense will stockpile the ruling as future appeal ammunition if a verdict cuts against them.
We have the latest from federal court in the Sean Combs criminal case. Status of jury selection, what Diddy's going to be wearing, violation of a gag order, rejecting a plea offer.
Outside the courthouse, grassroots survivor advocates plan banners, urging accountability while loyalists promise solidarity chants, forcing marshals to create buffer zones reminiscent of the Harvey Weinstein crowd control blueprint. Meanwhile, civil plaintiff attorneys weigh filing amicus briefs, opposing venue change, rare but not unprecedented when separate damage suits hinge on overlapping record. Talent managers scan developments, fearing a precedent that fuels venue shopping, waves whenever a hashtag erupts. Risk consultants update brand clients on scenario matrices, plotting public sentiment shifts tied to any ruling. Late Sunday evening, the parties lobbed final briefs. The defense's 127 pages, bristling with neon heat maps and algorithmic flowcharts. The prosecution's concise 12 pages, leaning on crisp precedent language. Within minutes, legal analysis blogs posted side-by-side breakdowns, and Diddy Motion vaulted to trending ranks, ironically highlighting the very dilemma at stake. Inside war rooms, defense paralegals map alternate districts' media footprints, plotting population stats and prior celebrity trial experiences.
Music mogul Sean Diddy Combs back behind bars, a magistrate judge denying him bail, saying that there were no conditions that she could conceive of that would make her confident that he would appear again for other court appearances. The judge saying, "My concern is this is a crime that happens behind closed doors."
While prosecutors refine opening statements, rehearsing under fluorescent lights as interns role play, skeptical jurors. Editors at cable networks cue veteran analysts who once covered OJ, Martha Stewart, and the Crypto Festival fiasco, while podcasts schedule instant react specials. The content ecosystem feeds on uncertainty, and this motion offers a buffet. Quiet personal dramas simmer too. A one-time studio intern turned mid-level executive considers flipping for immunity on unrelated tax inquiries. A flight attendant debates. Selling charter jet snaps to tabloids if anonymity holds, and each peripheral player warily measures moral calculus against risk. None of these subplots will matter more to the eventual 12 citizens than their oath to weigh evidence, but the battle over where those 12 sit could push opening statements well into autumn or even the new year, rewriting leverage dynamics. At every settlement table, investment analysts circulate contingency notes guessing stock jolts for partner brands from tequila to television if trial headlines skew dark, while philanthropic boards brace for fallout across scholarship funds. Bearing Combs' name, all eyes drift to a humble digital docket outside courtroom 26B that updates every 15 minutes. And seasoned reporters hover with lukewarm coffee, unwilling to miss the line where the clerk locks Tuesday's hearing or reschedules it for witness conflicts. Radio hosts debate whether celebrity capital buys endless procedural detours. First Amendment scholars parse the tension between open courts and viral saturation, and advocacy groups leverage the moment to push legislation strengthening survivor protections. As Monday bleeds into early Tuesday, lawyers pace under city lights, paralegals flag new docket pings, security teams finalize magnetometer locations, and expert witnesses practice slide transitions in cramped hotel rooms. Should Judge Vasquez shift the jury pool, marshals will draft travel protocols, neighboring district courts will shuffle calendars, and hotel managers will scramble for block bookings. If she denies the request, voir dire begins under even, harsher microscope, aware appellate judges could later comb every exchange for missteps. Defense strategists, fully cognizant of optics, frame the motion as constitutional necessity rather than delay, circulating talking points that emphasize faith in due process. Simultaneously, prosecutors signal confidence, quietly trimming slides. To appear unbothered, the decision will either set a fresh logistical blueprint or cement the current schedule 6 weeks out, sending price models, public narratives, and brand crisis management roadmaps spinning on new axes. So the legal stage is set, the spotlight fixed on Judge Vasquez, and every stakeholder, plaintiffs yearning for closure, defendants guarding empires, observers crafting headlines, holds collective breath for the gavel strike or electronic order upload that will dictate the next chapter in United States versus Combs, a saga already redefining how 21st century information flows collide with the Sixth Amendment promise of a fair jury.